So, Judy, thank you so much for talking to me today. Everyone will have seen that Meta has been in the news recently. There's been lots of litigation concerning their way of working and their way of doing business. Could you give us a brief synopsis of what's happened and why is it such a big deal?
Yeah, the most recent activity involving Meta and the alleged violations of the GDPR really got everybody's attention. I'm sure because the amount of the fine was so massive, €2 billion. As of today, that's around $1.3 billion. It's definitely an attention-grabbing fine. And the reason the fine arose out of Meta's transfer of data of EU citizens, personal information from the EU over to the US. And the regulators deciding that there weren't sufficient protections in place to be compliant with the GDPR. And the decision has some very, very interesting language. It talks about systemic, bulk, repetitive, ongoing transfers impacting over 309 million people a day. It's the data of over 300 million people being transferred every day. The decision is interesting because it talks about the state of mind of Meta when conducting these transfers. And they said there was enough evidence to show it was knowing, but it didn't meet the level of intentionality under GDPR, which would have imposed an even higher fine. But they use this term serious negligence. They were acting with serious negligence. I'm not quite sure exactly what that means, but that's what's happened. And of course, Meta is saying this is all wrong and they were in compliance and they were acting lawfully. Some commentators who are privacy experts, which I am not, have spoken about how Meta is kind of caught in between two legislative schemes, between the US law and the EU law. And they also point out that this is important for everybody to understand, but unless you are in this kind of business of transferring and then processing in the US, this type of data at this type of scale, it may not be such a big issue for other companies. I don't know about that. I'm not, as I said, I'm not a privacy expert. But I think in terms of insurance, this case shines a really bright spotlight on this issue of exposure, privacy exposures to companies that then can turn into cyber insurance claims, even in the absence of any type of data breach or security event of any type.
Could you expand a bit more on that? What kind of trends do you think may arise out of this and how soon are we going to see changes?
I don't know if we're going to see any changes, but let me take the first part of your question first. And a lot depends, of course, on the wordings of any particular cyber insurance policy, the regulatory coverage. Some policies limit exposure or limit coverage for regulatory investigations and fines and penalties to incidents arising out of a data breach or a security event. And that type of coverage should not be implicated by something like this, unless there's a credible argument that by sending that data, there was a data breach of some sort. But for other policies that have broader coverage for violation of any privacy law anywhere in the world, this kind of coverage could be implicated. And obviously, this was a real attention-grabbing incident, but I'm personally dealing now with a number of cases arising out of alleged violations of privacy laws where there hasn't been any data breach. This is not an isolated incident by any means. And as the regulators are getting more active in the EU and more privacy regulations being enacted, privacy regulations and laws being enacted in the US, and we also have more regulators in the US getting involved with privacy issues and cyber issues, including the FDA, the Federal Drug Administration. Even we've had the FTC for a long time. We have different attorneys general, but There's just more people getting involved. And the more people get involved, the more laws that are getting enacted, the more regs that are getting implemented, the greater this exposure is going to continue to be. And the challenge on the cyber insurance side is, how do the underwriters address this exposure on the front end? And when you look at some of the decisions that come out of these different regulatory bodies where they're talking about what companies have done, at least when I read it, I see a level of subjectivity in a lot of the decision making, such as what you had in your privacy notice wasn't perfectly clear, or it might have been confusing to some people. And it's very, very hard, I would think, for an outsider, an underwriter, to look at any companies given privacy notices, if they even do that, and say, is this sufficiently clear under an evolving regulatory scheme? And we're dealing with matters of first impression. And we don't have always like a body of case law that tells us, well, if you do it this way, you're definitely going to be in wrong. But if you do it this way, you're going to be fine. It's a complex thing to look at something and say whether it passes muster or not. We can't expect every underwriter to be an expert on every single privacy regulation out there in the world, and to kind of predict how a regulator would look at these things. Another factor is that, and we all know this as consumers, privacy notices change all the time. Companies change how they do business all the time, and they update their privacy policies and notices all the time. So it's an ongoing, very fluid situation that kind of adds to the complexity of the issue as well. When you think back over the past few years, where the loss ratios kind of got upended with ransomware and other security type of threats, we saw the underwriters really take action and increase their scrutiny. They became much more detailed about what they were looking for. Certain types of controls have to be in place as table stakes to even get to the table to get a cyber insurance policy. Now, the challenge will be creating that same level of scrutiny on the privacy side for insurers that are writing this type of coverage, creating that similar type of scrutiny so they can analyze these privacy risks. Some insurers say they focus on a culture of compliance and they look for certain indicia of that, such as, do you have certain officers and employees dedicated to these privacy focused roles? But I think insurers would be well served to look at these decisions that are coming out, and they're long. The Meta decision was over 200 pages. But go through these things and try to get a sense of what the underwriters are looking for. And I think that will help underwriters come up with the right framework of focus when they're dealing with their insureds. Here in the US, lots and lots over the past year of class action lawsuits have been filed for privacy issues having nothing to do with a data breach or a security event. You probably have heard about these pixel cases.
Yeah.
So there's pixel cases that there's this code on people's websites that are allegedly capturing bits of data and transferring them to Meta or to others. There's also cases under a law called the Video Privacy Protection Act, where there's the allegations are that the insured is, or the defendant, I should say, is not properly getting consent and giving notice that they're capturing, they're tracking your video watching history, basically. The interesting thing about that is that law, like so many of these other laws, that law was enacted way before anybody knew anything about cyber. There was a Supreme Court confirmation hearing in the US back in the 80s, and it was very controversial.
Wow.
And
What was the main concern there? Were they trying to prevent or protect, I guess, at that point? It wouldn't have
Apparently
been
reporters were going, this is probably before your time, but reporters were going to the local Blockbuster store where the Supreme Court nominee lived in his neighborhood. And that's when people used to go to the store and rent videos. And they were trying to find out what videos he had been watching in his home, like his private video watching history. And people were offended by that. And so this law passed, and this law is being used now to bring some liability for people looking at videos on websites. There are some laws in California, like the California Invasion of Privacy Act, which is a penal law that has a private right of action, believe it or not. And that's decades old as well. And they're saying all these chat features on websites are collecting information in violation of the California SIPA, Invasion of Privacy Act. Lawsuits are also being brought under wiretap statutes, saying that you're allowing a third party to come in and intercept my communications with you. My clients and other insurers are being inundated with these types of lawsuits. Now, whether they have any merit on the facts, it's early days, we're not sure. A lot is very fact specific as to what that particular company was actually doing and whether the information they were sending, for example, was it really protected information? Was it PII? Was it PHI? But I guess the point for our purposes today is these cases are being filed with a high degree of frequency, and they're class actions, and they're very expensive to defend.
Yeah.
And if you get it dismissed on a motion to dismiss, you're looking at either something very expensive to defend or potentially expensive, depending on the facts and the law, et cetera, very expensive to settle. The biggest settlement, and one of the first, involved a hospital in Massachusetts that settled one of these cases for $18 million.
Wow.
So this is what we're seeing here. So the exposure can come from laws, it can come from regulations, it can come from common law.
Yeah, cases that are being decided.
Yes, and none of them involves that typical concept of a data breach, like a hacker coming in or a security event. And what the insurers are basically doing when you're covering any violation, providing coverage for any violation of any privacy law, is you're basically insuring business processes. And that's the trick. How do you ensure that their business processes are compliant with this complex, everybody uses this word patchwork, and it's a good word, this complex patchwork of evolving and emerging privacy laws and regulations, or older laws that are being used for those purposes.
Can I press you a little bit further then and ask you, we have the minimum controls that insurers are using as standard now in order to assess whether someone is policy ready or not. In terms of minimum controls that could be put in place for a privacy exposure point of view or for a regulatory exposure point of view, looking at the Meta case, is there anything that you could say right now or underwriters need to be doing further research on based on the decision that was made?
You definitely want to read the decision or have somebody read it for you and highlight the fine points because it's so long. But it might prompt insurers to ask questions. Are you transferring EU residents' personal information to the US? How much are you doing it? Where is the data processed? Are you processing it in the EU before you're sending it over to the US? And what type of information is it? And you can kind of get a sense of whether that exposure exists or not. So those are the types of questions I would be expecting underwriters to look at now based on Meta. So again, the court was the regulatory body was so focused on the type of data, how long it had been going on for, the sheer numbers of people involved. It leaves a trail of areas of inquiry I would think underwriters would be interested in. I know underwriters already are looking at or asking their insureds about pixels. Are you using pixels on your websites? Things of that nature. So we might start seeing greater scrutiny of privacy policies as well. Or if not, imagine underwriters sitting there and reading every word of a privacy policy, but asking if you have qualified counsel, inside counsel or outside counsel that's doing that for you, and how often are they doing it? Are you getting legal sign off that you're in compliance? And even if a regulator disagrees with you, it helps you paint a better picture of,
it gives you a better chance, I guess, if push comes to shove.
Trying to be compliant, doing your best to be compliant, and avoiding that situation of serious negligence, whatever that is, and and God forbid intentional conduct.
And from a broker perspective, if you need to call my clients now, or if my clients are asking me, what does this mean for me? Does this mean anything for me? What do they need to be saying, or what kind of points should they be picking up on from
this is where having a really good broker really pays off. Somebody who understands your business, how you do business, and the types of data you're collecting and using, and kind of what you're doing with it. Everything from, are you scanning for biometric information? Are you doing like these data transfers from one country to another country? Having a broker who understands the business operations plus stays current on what the regulators are doing, what the plaintiff's bar is doing, and they can kind of highlight these things. If you go online, you'll see some of the best blog posts out there on these exposures are written by brokers, and I love seeing that, because they're the front line with the insured very often. And not only to help them prevent the exposure, just to prevent the exposure, but also to put their best foot forward when they're going to their insurance company to get the coverage.
It's always key in this industry. Exactly. Keeping up to date, keeping on top of what's going on, it's key. And besides the Cyber Insurance Academy website, where we have lots of resources and information and updates, you mentioned some other really good blog posts that you've seen and articles. Could you recommend some specific resources for people to keep an eye on for that kind of stuff?
Honestly, one of the things I do every single day is I literally do Google searches for these issues every single morning. And then you'll see them pop up on different brokers' websites or in publications. And some publications are better than others. And like anything, that's insurance focused, because you can really go down, the rabbit hole of all these compliance issues. And complying with the 99 articles in GDPR is very challenging, not to mention all the different laws popping up in the US every 5 minutes. So I think understanding in a broader way what the exposures are enables the broker to tee these issues up with their clients. And hopefully, when the broker's having these discussions and the insureds are filling out their cyber applications, they have the right grouping of people around the table that are involved in all this. You don't just have the lawyer, you don't just have the risk manager, you don't just have the CISO, you have all of them. And if you have a chief privacy officer or somebody who's in charge of that, they should all have a seat at the table. And I always recommend include the marketing people, because they don't always understand the legal risks. They understand what's technically possible, but they may not understand whether it's legal or not. And I always advocate for having the marketing person have a seat at the table as well. And when you get that grouping of people together looking at these issues, not only do you avoid some of the low-hanging fruit mistakes, but you also make yourself a more insurable risk.
That's brilliant. Thank you. That's all we have time for, but thank you so much for your insights. It's been a really interesting discussion, and I think we're all waiting to see how the impacts of this case unfolds.
I think it's great you're focusing on these issues, so thank you.